It's interesting that this is the 150th anniversary of the foundation of British Columbia. You'll see it on government letterhead, the 150, it's like a centennial and a half that's being celebrated. In 1858 was the Fraser River Gold Rush, and that was the triggering event to form a colony because the British Empire was concerned that this would become part of the United States. Most of the gold rush seekers were Americans. And so there was a scramble in London to form a colony. Queen Victoria was asked to find a name for the colony, and I've got the letter that she wrote. It's a classic of imperial detachment, because she didn't know anything about this place, and so she said, well, it has to be British, and it's over in the New World, so we'll name it after Christopher Columbus, and so she called it British Columbia. Which has nothing to do with the amazing diversity and beauty of the province. What's interesting is that prior to 1858, British Columbia had a name. In the British Empire, it had an official legal name, and that name was the Indian Territories. And that name was changed in 1858 from the Indian Territories to British Columbia. And from that point on, the British and then eventually Canadian authorities have systematically ignored the Indian rights that used to be here and still are latent but unrecognized. So since 1858, there's the unresolved issue is called the Indian land question, or the Aboriginal title question. And that's a huge problem. It's a problem that few jurisdictions have, which is that after all of the land has been alienated and industrialized, we're coming after the fact to try and resolve the question of who owns the land. It's very difficult. It's a world-class problem that BC has, which is that forestry, mining, hydroelectric developments, roads, and now independent power projects are all located on land that, to a certain extent, belongs to the First Nations. And when I say it belongs to the First Nations, I mean that in the sense that they own the land just as an ordinary homeowner owns their house and their backyard. We know that now from a decision of Mr. Justice Vickers of the British Columbia Supreme Court in November of 2007. It's the Tsilhqot'in decision. It's called Tsilhqot'in Nation versus British Columbia. This is a copy of the decision in this red book. It has an entire book to itself because it's a very long decision over, well, just about 500 pages. And that's because it was a very long trial. It was a 339-day trial. But as a result of that decision, we now know that there are places in British Columbia where Aboriginal title actually exists and where the Crown has no argument or defense to deny that Aboriginal title. On the map behind me, you see the area that was subject to the court case. This is an area southwest of Williams Lake, the other side of the Coast Mountains, that is the eastern side of the Coast Mountains. Really, if you drew a line straight north from Whistler, you'd come here. And it's a relatively remote area of the province. No major highways go through here. All of the areas marked in green were subject to the claim of the First Nation, a claim of Aboriginal rights and Aboriginal title. The areas marked in dark green are the areas where the court found that Aboriginal title exists. That's about 45% of the original claim area. Well, the first thing that's interesting about that is the magnitude of the claim, that 45% of the claim area is Aboriginal title lands. If that was the case across British Columbia, and taking out the areas of British Columbia already covered by treaties, we would certainly be looking at hundreds of thousands of square kilometers of Aboriginal title land. Now, it's hard to know if the same reasoning would apply in every part of British Columbia, but at least it gives us the goalposts. And what's interesting about this is that until now there haven't been any guidelines. There's been a lot of talk about Aboriginal title, but there's been very little on-the-ground expression of of where it is and what it looks like and what it means. So the importance of the Tsilhqot'in Nation decision in November of 2007 is that for the first time we can look at a map and see where Aboriginal title is, and we have a description from the court of what it actually means on the ground. Now, it was a fairly large claim area, an area of about 4,500 square kilometers, or I think maybe it's 440,000 hectares is what it was. That's a big piece of land. The court awarded Aboriginal title, or said that Aboriginal title had been proven, and there are no government defenses applicable, to an area of 2,000 square kilometers, or 200,000 hectares. And that works out to about 45% of the claim area. What's interesting about that number is that it's a much bigger number than has been officially estimated. If you think of the offers at the treaty table in the BC treaty process, they range from a high of about 7% to a low of maybe 1% of the traditional territory is being confirmed in treaties. Obviously, 45% is a vastly greater proportion of the lands of British Columbia being subject to Indian ownership than either the federal or the provincial government have ever contemplated. So this is a shakeup. And if you extrapolated that result throughout the territory of British Columbia, and you can't really extrapolate it because some First Nations will achieve much closer to 100% of their traditional territories, and perhaps some might achieve less than 45% of their traditional territories, but this is the only case we have. So the first case that comes out says 45%. That's a very dramatic result. British Columbia has approximately 1 million square kilometers. 45% of that is a lot of land, you know, bigger than Belgium. And we're talking about ownership, ownership of the trees, ownership of the soil, ownership of the land, the right to the full economic potential of the land. Beginning in 1858, when the colony of British Columbia was carved out of the land previously known as the Indian Territories, there have been gold rushes and land rushes and basically resource exploitation rushes throughout British Columbia's history. Of course, the first one was the 1858 gold rush. But systematically, through all of the periods of British Columbia's history, people have come to this province, or people in this province have done greater and greater degrees of exploitations of the amazing natural resources available here. Of course, forestry, mining, hydroelectric development. The most recent gold rush is the independent power producers' rush to exploit the small rivers and streams of British Columbia for independent power supplies. And normally we would have expected that to be carried on by BC Hydro, but what has happened in the last decade has been the privatization of the electric potential of these small rivers. And that happens through the granting of water licenses, so that a private party then has the right to exploit the electric potential in a small river or stream. Now, what's problematic about that from the First Nations point of view is that this is all occurring on lands to which they have a very strong and credible claim of both Aboriginal title and Aboriginal rights. Now, Aboriginal title and Aboriginal rights are two different things, and it'll take a minute to explain the difference. But if I start with Aboriginal title means ownership of the land. And British Columbia is famous in the world for having an unresolved question of Aboriginal title. You know that throughout all of the rest of Canada, or most of the rest of Canada, the question of Aboriginal title was resolved through treaties. And the same happened in the United States, even though Canadians are sometimes smug about their treatment of Aboriginal people compared to the United States. The fact is the United States signed treaties throughout their territory, and that's not what happened in Canada. In British Columbia, treaties were not signed, and the First Nations maintained through the whole 150-year history of the province opposition to the taking of their lands without any payment or compensation or any formal or official process. And just now, in 2007, in November of 2007, we have a judge of the British Columbia Supreme Court saying that that has been illegal, and it has been on shaky ground. He called it skating on thin constitutional ice for 150 years. That British Columbia has simply been violating the law by alienating the lands and the resources of First Nations without the underlying question of who owns those resources first. Some people think the Indian land question is a new issue. That's because they read about it in the papers and they think it's new. But any historian can tell you that it has been a persistent issue that the First Nations never did give up. They have always, every year, every decade, at every part of the history, First Nations have been saying that they own the land. Prior to 1951, it was a criminal offense for them to organize or raise money to advance their land rights. That was a particularly sad part of the history. But in the 50s, when it became legal to advance land claims, almost immediately First Nations went to court. And in the 60s, the great late Chief Frank Calder of the Nisga'a Nation went to court and made one of the first impacts through the taking his case to the Supreme Court of Canada, who laid one of the foundation cases for Aboriginal title in Canada. And their lawyer was Thomas Berger. And there's been, since the Calder case, there's been 3 other cases that have advanced Aboriginal title through the courts. You may have heard of the Mears Island case in 1984. In 1985, the British Columbia Court of Appeal granted an injunction to stop Macmillan Bloedel, a big logging company in the province. It's now owned by Weyerhaeuser, but at that time it was called Macmillan Bloedel. And an injunction that prohibited Macmillan Bloedel from logging Mears Island, even though Macmillan Bloedel had a license from the provincial government that said they could. And the reason the Court of Appeal granted that injunction was because of the possibility that those New Chalneth nations had Aboriginal title to Mears Island. In the years following that, the Gitxsan and Wet'suwet'en people went to court and all the way to the Supreme Court of Canada, claiming Aboriginal title to their territories, an area in northern British Columbia near Smithers. And the Supreme Court of Canada said there is Aboriginal title in British Columbia, but they didn't say exactly where. They told the Gitxsan and Wet'suwet'en to go back to court. And they haven't done that yet. They haven't gone back to court, but no doubt at some point they will do that. The fourth in these line of cases is the Tsilhqot'in Nation case, on which I was counsel, and which went to court over a period of 18 years and resulted in a decision in November 2007, in which the British Columbia Supreme Court, Mr. Justice Vickers, found that Aboriginal title had been proven in an area of the Tsilhqot'in territory, and that there were no government defenses. All of the government arguments and defenses were swept aside. And that area is shown on this map, the area in dark green. This is about 2,000 square kilometers, or 200,000 hectares. It's also about 45% of the area originally claimed in the court case. So for the first time in 150 years, we have an indication from the courts of the scope and magnitude of Aboriginal title. In this particular case, the Tsilhqot'in people convinced a court that they have Aboriginal title to 45% of the lands that they had been claiming in that court case. Obviously, if you extrapolate that throughout British Columbia, we're talking about the potential of hundreds of thousands of square kilometers of land that are owned, in a very real sense, owned by the First Nation. Here's what Aboriginal title means. And this is stated throughout Canadian and American and British and Commonwealth case law, but it's restated in the decision of the British Columbia Supreme Court of November of 2007. Aboriginal title means that the First Nations own the land in the sense that any owner owns the land and have the right to exclude other people who are trespassing on the land and who are exploiting the resources contrary to the interests of the First Nations. It does mean something interesting in Canadian constitutional law as well. It means that only Parliament, only federal laws can apply to the use of those lands, and provincial laws don't apply. So, for example, the law would indicate that the Forest Act of British Columbia, the Mining Act, all other statutes that relate to the actual use of land, the Land Act, for example, these statutes don't apply on Aboriginal title lands. Only Parliament in Ottawa could pass such laws. And Parliament, when doing that, would have to take into consideration the best interests of the First Nations. So the purpose of that part of our Constitution, it's always been known, is so that the more distant level of government, which is not cluttered by local interests and not influenced by the present urgencies of neighboring towns and municipalities, that more distant government could take a more dispassionate look and fulfill its responsibilities to protect this vulnerable minority, the Aboriginal peoples. So it's always been part of Canadian law that it's Canada that should make treaties, that the provinces are not in the business. In fact, they have no constitutional authority to do so. Well, we now have a decision that points out where Aboriginal title is in British Columbia. We have a map, we can see it, you can draw a boundary. A surveyor could go and say, well, this land is subject to Aboriginal title, and the land outside it, we don't know yet. But certainly within these boundaries, there is Aboriginal title. And we know that provincial statutes that affect the use of land don't apply there. So if you want to take a very current example of the importance of this, think about the independent power producers who have recently obtained leases and water licenses in order to advance microhydro projects, for example. They obtain a water license that enables them to harness the electric potential of a stream, and that involves building a road to the site, building a dam and a penstock, perhaps building a transmission line to take the electricity back to the grid. All of this involves infrastructure on the ground. It involves the use of land. If those lands are Aboriginal title lands, then the alienation of those lands away from the First Nation who rightly owns them is not legal. It's not constitutional. It's contrary to the Canadian Constitution. This is a big problem, that 150 years into our legal history, those kinds of mistakes are still being made. I have to emphasize that the British Columbia Supreme Court is a cautious and serious court, but it was prepared to say in November of 2007 that British Columbia has been skating on constitutional thin ice for 150 years. This is a world-class problem and one that has to be solved. Clearly, British Columbia is ill-suited and incapable of resolving the problem by itself, and it'll require the help of Canada, the federal government, and Parliament. One would have expected that even within a few months of the decision in Tsilhqot'in Nation, we would have had statements by Canada about how they intend to assist British Columbia in resolving this problem. It's a very serious problem about who owns the land upon which the resources and economy of British Columbia depend. In Canada, the question of how First Nations are governed is quite complex. They are political entities just like the federal and provincial governments and municipal governments. Perhaps even more complicated because since the Indian Act came into force, it came into force in British Columbia in 1876, there's been often two parallel systems of government for First Nations. There's the original, customary, indigenous systems of government, sometimes called the hereditary chiefs, although they're not always hereditary. Sometimes the customary government is an elected system. But the customary governments on the one hand, and then there's the Indian Act system of government, which is often called the elected system, although Sometimes that's a misnomer because sometimes the Indian Act system is, in fact, not elected. But if for rough purposes we talk about the Indian Act elected system and the customary hereditary system, you'll know what I mean. For many First Nations, in my experience in British Columbia, for many First Nations, these two systems exist in parallel. And to put it very roughly, the band councils, the elected band councils under the Indian Act have jurisdiction over Indian Act matters, which generally speaking means on reserve matters, matters on Indian reserves. And very roughly speaking, the customary councils, or the hereditary chiefs, have jurisdiction over the matters that are not under the Indian Act, or in other words, the off-reserve matters, the areas outside the boundary of Indian reserves. Now, Indian reserves in British Columbia are very small. They're actually notoriously small, and they're like, some people have said they're like postage stamps on a letter, but you know, even a postage stamp on a letter is bigger proportionately than the size of Indian reserves within traditional territories. If you see a map of reserves in a traditional territory, you'll notice that they're very small, often 40 or 160 acre parcels within the greater territory in which the First Nation has its lands. So most of the important resource decisions that take place off reserve, and there's not much uniformity in how this is dealt with in British Columbia. Or maybe I should put it this way: everybody's confused about who the correct authorities are. It's true that the elected band councils operate under the authority of the Indian Act, under the authority of the federal government, and quite often they are the legitimate continuation of the traditional government of that Indian nation. And in those cases, the Indian Band Council is the body to deal with. But in other cases, parallel to the Band Council, you'll have a system of hereditary chiefs or some other form of customary government that is the correct authority with respect to off-reserve matters. All of those matters concerning forestry, mining, road building, hydroelectric projects, including independent power producers and microhydro projects. In many cases, the correct legal authority to deal with those matters is the customary government. Because after all, those customary governments have never lost their legitimacy under Canadian law. The Indian Act says nothing about, the Indian Act is silent about the jurisdiction of those governments. The Indian Act only talks about on reserve matters. So, as the law develops with respect to Aboriginal rights and Aboriginal title, and as maps like the one I'm showing you here begin to develop throughout the province, and we can identify Aboriginal rights areas and Aboriginal title areas, and all of these are off reserve, it'll become more and more important for the federal government, the provincial government, local governments, and private industry to know who they're dealing with. Are they dealing with the Band Council with its jurisdiction on reserve? Perhaps the Band Council, for historical reasons related to that First Nation, also has jurisdiction off reserve, or maybe, as is in the case of many other First Nations in British Columbia, it's a system of hereditary chiefs or a customary government that is entitled to exercise jurisdiction off reserve. Well, that's a tricky question, and if you want to know that you're dealing with the correct party, you need to know something about the history and constitution and culture of the particular First Nation you're dealing with. And I know that many non-Indian people are impatient about this and don't want to spend the time, but I'm afraid they will have to spend the time to learn who they're dealing with, to learn about the history and the laws relating to the particular First Nation they're dealing with. You know, British Columbia is remarkable in its diversity. There are so many different, there's 200 different First Nations, but they fall in ethnic groups that have amazingly diverse cultures, languages, and histories. And they're not all just Indians, as Christopher Columbus named them. They're First Nations as diverse from one another as any nation in Europe is from its neighbor, or even perhaps as Russia is from China. These are very diverse peoples with very diverse histories and cultures. So the question of who you should be dealing with when dealing with off-reserve matters is a complicated question, and one that requires respect, first of all, for the First Nation, and some research and some consultation in order to find out who the party is that one ought to be dealing with. You know, in 1858, when the colony of British Columbia was founded, it was because of the gold rush, and the gold seekers were a particularly rowdy and unrestrained bunch, and the British authorities felt that they had to impose some legal restraints on them in order to bring them under control, because this was the Wild West, and they felt like they could just do anything they wanted. So, you know, famously, Governor Douglas set up a barge in the middle of the Fraser River and charged them all $5 apiece if they wanted to go up the Fraser River and pan for gold. The strange thing is that 150 years later, the same culture and mentality seems to show itself with respect to the new privatized sector of our energy industry, the independent or private power producers. They approach the question of privatizing the water rights on British Columbia's small rivers and streams as a kind of gold rush, and it's a kind of a presently unregulated free-for-all where they can go in and make some big profits in a short amount of time. Well, I would say, well, fair enough, that's what happens in a gold rush, except that in this particular case, there are some seriously affected, even victimized people. And these are the Aboriginal peoples who appear to have substantial rights and ownership interests in those very lands. And so here we have the problem with some very well-funded and highly organized people coming in to exploit yet another one of British Columbia's resources. And they are, the resources that they're exploiting, the transmission lines, the road rights of way, the rights to the water itself, in order to establish these privatized power plants, may well belong to, or at least impact on, the title and rights of the local First Nation. And I haven't seen a great deal of understanding or even respect for the First Nations involved. You have to remember that the First Nations in British Columbia have been brutally repressed by being kept in a state of poverty, by being denied legal rights well past the middle of the 20th century. They were not allowed to go to court to assert their rights. They were not allowed to vote until 1960. They were not allowed to organize, and they were kept in a state of poverty because the asset that they owned, their lands and their resources, had essentially been confiscated. We're now able, finally, at this late stage in our history, to begin to establish the full scope and extent of Aboriginal rights and title. And just as that is happening, at the same time, the new gold rush is going on, the rush to exploit some of the last of the frontier resources of British Columbia. And I'm talking about the rush to privatize the electric potential of small streams through the privatized power process. I'm talking about alienation of foreshores to create licenses for salmon farms and other kinds of aquaculture. I'm talking about the granting of a kind of private right over wilderness areas in order to create monopolies for various kind of recreational activities such as heli skiing and whatnot, so that even the very frontiers of British Columbia's resources are being privatized right now as we speak, just at the moment that First Nations are finally able to get justice in the courts about what they own. Well, this is a serious problem, and surely there should be a kind of time out, a kind of pause in the reckless disposition of interests in British Columbia's resources in order to allow everyone to catch their breath and consider what they should do. There's a serious danger involved in the the provincial government of British Columbia's current rapid disposition of water rights and other kinds of private interests in land, which is that eventually the people of British Columbia are going to have to compensate the First Nations for that. We now know that there are major and extensive Aboriginal rights and title throughout British Columbia. We know that loud and clear. We've been told that by the Supreme Court of Canada over and over. We now have on-the-ground decisions by the British Columbia Supreme Court. And in the face of those decisions, in the face of all that notice, the provincial government continues to dispose of and alienate those resources. Well, that's clearly just giving away someone else's property. And the province of British Columbia will be held accountable and will have to pay for that. And that will come out of taxpayers' pockets. So it's unbelievably reckless, and from a business point of view, to expose the taxpayers of British Columbia to this kind of jeopardy. What's happening in British Columbia is two things are happening at once. The scope and extent of Aboriginal title and Aboriginal rights is now being fully exposed by the courts, and we're finding that in some parts of the province up to 45% of the land is subject to Aboriginal title, ownership by the First Nations. At the same time, in these same years, the Crown, the province of British Columbia, is alienating resources such as the rights to exploit the electric potential of small streams and rivers and make independent or private power projects over the very same resources that First Nations may have Aboriginal title and rights to. And so there's two kinds of danger that flow from that. First of all, there's a danger to the taxpayers of British Columbia because they may well have to, having been given all this notice by the courts, they may well have to compensate the First Nations for what has been recklessly given away. There's also a danger to the investors who it's not clear, it's not 100% clear that a First Nation is prevented from getting what they owned so recently, prevented from getting it back. So, you know, I'd be very hesitant to invest in a project that may well be taking place on someone else's land. You know, there is going to be, I suppose, the guarantee of the Crown that they'll stand behind the grant that they've issued. But I sure wouldn't be confident about a renewal of that license. I wouldn't be confident about any sympathy from the courts about that license, because everybody knows that this is happening on lands that are in dispute, in a notorious and public and long-standing dispute that is now being resolved in favor of the First Nations. Why would you invest in something in the middle of that atmosphere? Now, of course, a risky investment should produce a high return, and I understand that many of these projects produce a high return, and so that might comfort the investors. But in terms of a long-term investment, I think that in the long term we're going to see some pretty vigorous battles, probably in court, to resolve the underlying land question, and it may turn out that the landlord is not the province of British Columbia, but the local First Nation. I'm a lawyer and I normally represent First Nations. And if I was advising a First Nation that was entering into an agreement with respect to a private power project, I would advise them to put in a clause that says this agreement is made without prejudice to Aboriginal title and rights. And I think you'll see that in many of the agreements that have been entered into, you'll see that clause. Well, what that means is that the whole agreement is hanging on a thread, because if there is proven Aboriginal title and rights, the whole agreement has to give way to that proof. So the First Nations have been quite clever in inserting that clause, or quite well advised, I should say, to insert that clause, and I think that that's not a meaningless phrase, as we know from recent court decisions. The second thing is I would advise the First Nation to be very clear about who has the authority to enter into such an agreement, because nobody, neither the First Nation nor the private party involved, wants to be faced with a situation down the road where it turns out that it was the wrong party that entered into the agreement. Now, that's a complicated question. In some cases, the elected Indian Act Band Council is exactly the right party. but in some cases it's exactly the wrong party. And you have 197 Indian Act First Nations in British Columbia, and you'd have to investigate in each case who was the correct contracting party. Now that's just two examples of the technicalities that are involved in entering into these contracts. Now, there's technicalities in every contract, but in these particular contracts, the foundation is an area of law that is so rapidly developing and so very unclear that I wouldn't find very much comfort as an investor unless I had a good insurance policy, because it's possible that the very foundations of the contract, the party and the property being dealt with, are not as one might have expected on a superficial reading. One of the problems with the gold rush that's happening right now, the 150th anniversary gold rush, which is the granting of hundreds of licenses to private power producers, the privatization basically of the electric potential of the small rivers and streams of British Columbia, is that it's being done without adequate federal supervision. The federal government is responsible for the great fisheries of British Columbia, one of the great fisheries of the world, and the federal government doesn't seem to be a player. They don't seem to be part of this process. They're there to protect the fish for all Canadians, indeed for the people of the world. They're also there to protect the fish for the First Nations. And the federal government is not doing a good job right now of protecting the fish resources that might be threatened by these private power projects. Now that's a difficult technical question, and you'd want to ask every fisheries biologist you could, and you'd want to take a precautionary approach to the solution to that problem, because what if one of these power plants changes the quality, the flavor, the flow, the temperature, or the sedimentation, some other aspect of the stream? As we know, fish are extremely sensitive, and we can't risk the fact that they might stop coming up a particular river to spawn. That's too dangerous. Now, where's the federal government in this? That's what I'm worried about. The federal government must be involved in protecting each and every stream. We can't squander a fish-bearing stream in order to make cheap electricity. We also need the fish, and the First Nations need the fish. So that's a very important issue, and I'm worried that the federal government is not doing its job.